So let's see. From my side, good afternoon. I'm actually not from here, but right next door. I'm Paloma Frötefalk. I'm associate professor at the University of Tartu in constitutional law, but I'm also a member of the board of the Estonian Human Rights Center. And actually, in this position, I'm replacing our executive director, ECHR, who regrettably fell and had surgery and has to rest. So from here, our best wishes to him. Get well soon. But with this, I also have the pleasure to briefly introduce Tobias Locke, professor of law specialized in EU law and EU human rights, fundamental rights law at Maynooth University, Ireland. He is especially focused on the EU Charter of Fundamental Rights as well as its relationship between EU law and the European Convention of Human Rights. He has also previously held the Jean Monnet Chair in EU law and fundamental rights, and beyond that, beyond academia, also contributed with expertise to several parliamentary bodies in the United Kingdom and Ireland, also analyzed the implications of Brexit. So I'm very happy to welcome such an internationally acknowledged expert on these issues. And actually, his today's lecture is taking place within a project dedicating to strengthening the role and visibility of the Charter of Fundamental Rights in Estonia, helping to make it be better visualized and amplify its impact in legal education as well as in practice. And with this, it is co-founded by the European Union for Fundamental Freedoms through support from the European Commission. And without further ado, I'm very happy to hand over to Tobias Locke and curious to find out more. And yeah.
Well, thank you. Thank you very much, Paloma. Thank you, Professor Roets, for hosting us. Thank you to the Human Rights Center for organizing this and for inviting me. It's always a pleasure to be here. And now you can see what my lecture is going to be about the EU Charter of Fundamental Rights and the ECHR. I've been told to speak for about an hour and 15 minutes, so we'll see how good I will be at timekeeping. If you're lucky, I'll speak fast and you'll get out here quick. If not, I apologize in advance. So what I want to do today is, this is the overview. So I'll give you a short introduction on the EU and the ECHR. I will then address 2 points. One is what I would call the added value of the Charter. So why do we need a Charter of Fundamental Rights? What does it add to what you've already got under the ECHR, and you've also got a constitution. Most countries, anyway, in the EU have a constitution that protects fundamental rights in some shape or form. And then secondly, I want to look at interactions between the ECHR and EU law, and I'll give you a few examples. I'll do most of this by way of case studies of real cases that have been decided by either the Court of Justice or the Court of Human Rights. So I hope it'll be not quite as dry as you might fear. So we have here a map of Europe, obviously, and the countries in blue are the countries that are parties to the European Convention on Human Rights. What the map shows, not very clearly, but it also shows that every EU member state is also in a party to the ECHR. So every EU member state has the ECHR protections and it has the Charter protections at the same time. Now, the ECHR is much older. It celebrates its 75th birthday this year, whereas the Charter If you want to be generous, it's celebrating its 25th birthday, but it has really only been in force since 2009, so only for 16 years on the 1st of December with the Treaty of Lisbon. So 16 years, obviously a much shorter legacy. But I think it's long enough to now be in a position to assess how the two of them interact and what the added value of the Charter really is. Now, prior to the EU having its own charter, its own written fundamental rights catalogue, the Court of Justice had always, had been protecting fundamental rights since 1969. So it's a long, most of us, I certainly wasn't born, I think most of us in this room weren't born then. Since 1969, and they have been developed by the Court of Justice as so-called general principles of EU law. They are unwritten principles of EU law. You can't look them up. You have to look up the case law of the Court of Justice in order to figure out what they are and what they mean. But the main source of inspiration for those principles, general principles, was always the ECHR, because you have to start somewhere, and that was a common standard that all the member states had signed up to. Now, turning to the added value of the Charter. Now, I've tried. I'm not very good at graphics, as you can see, and I'm not very good at using AI to make good graphics. So this is what you get from me. But what I'm trying to show here is that we have a lot of overlap between the different protections that there are. We have an overlap between the ECHR in terms of substance. We have an overlap with domestic fundamental rights. I'm sure that wherever, I think there are a few Erasmus students in the room and obviously local students. Wherever you're from, you will find things like freedom of expression in your own constitutions. You will find something like, a right to life in your own constitutions, a right to property perhaps. All of these are substantively overlapping rights, and we have them in the Charter as well. So the question is, what do we need the Charter for? Why is the Charter any good to us? And I will try to demonstrate this. What it certainly does compared to the ECHR is, and I'll show you that in a second, is it protects additional rights. There are rights in the Charter that you can't find in the ECHR. It also is easier to enforce, right, than the ECHR. I will talk about that in particular. When it comes to national constitutions, well, it depends on where you are, right? But I would imagine that the Charter probably protects more rights than most national constitutions, and it maybe has certain advantages in terms of enforcement. That really depends. It's a trickier claim to be making. So I'm going to leave the national side out of it because I don't know anything about most national constitutions that exist in the EU member states at all. Okay, so if we look at this next slide here, you can see, I think, where we have overlaps and where we have differences. The green bits on this slide are the overlaps. So the Charter has a chapter on dignity, which protects human dignity, but also, say, the right not to be subjected to torture or inhuman and degrading treatment or punishment. And the ECHR protects that as well. You have the freedoms chapter, which protects freedom of expression, the right to marry, freedom of religion, and the Charter protects those as well. So this is a fairly large degree of overlap here. And the same goes for justice, the right to an effective remedy, which we'll look at, but also the right not to be punished twice, the principle of legality that criminal offences have to be defined at the time that you have committed them, so the state can't go back and say, well, you've actually done something in last year, which we have now made a criminal offence, and therefore we'd like to punish you. That doesn't work. You have to know what you're allowed to do and what you're not allowed to do at the time that you are committing the offence, or the alleged offence. So all of those are protected in both instruments. But we have this red bit in the middle where the Charter protects certain rights and where the ECHR doesn't, okay? And that's where we have this added value, certainly in terms of substance. Now we'll look at those in a bit more detail in a minute, but certainly if you're familiar with the European Convention on Human Rights, it mentions equality in Article 14, but it is a relatively weak protection compared to what the Charter has on offer. Solidarity, Chapter 4, is about social rights. We'll look at those in a little bit. Well, there's not really anything in the Convention, maybe apart from the right to an education. And citizens' rights, well, we don't really have either. Okay, now, slightly more granular overview on this one here. Now, you don't have to read all of this, don't worry about it, but you can see that the dignity and freedom chapters, there's a lot of overlap. Now, we have a few extra rights, and I know, I'm sorry, but the size of the font, some of you might have to bring opera glasses or something to read this, but we have a few rights that overlap completely. So Article 3 and Article 4, I've already mentioned. Article 3, ECHR, Article 4, right not to be tortured, is a copy and paste job. It's exactly the same, yeah? If you put them side to side. We have others that have been modified ever so slightly. For example, the right to marry in the ECHR is restricted to men and women getting married to each other. The Charter is more open. It can accommodate same-sex marriage, for instance. It doesn't give a right to same-sex marriage, but it can accommodate it. But you've also got additional rights that we don't find in the ECHR. One of them is the right to the protection of personal data, Article 8 of the Charter. We don't have it in the ECHR. The easy reason for that is that in 1950, data protection was not something people were thinking about as an issue. And obviously, living in 2025, 75 years later, it is indeed a really hot topic, right? The same goes with the freedom of the arts and sciences, which we can't find in the ECHR. It also protects academic freedom, for example, where the European Court of Human Rights has to use Article 10, the right of freedom of expression, to guarantee similar protections, okay? Now, this doesn't mean, and we've got a right to asylum, actually, in the Charter, which we don't find in the ECHR. That doesn't mean that those kinds of activities, if that's what you want to call them, those kinds of rights are not at all protected under the ECHR. What the European Court of Human Rights does is obviously it interprets the existing rights broadly. So data protection is protected as part of the right to private and family life, and the Court of Human Rights is obviously creative enough to interpret that right, the scope of that right, in a way that it protects people's right to personal data, right not to be subjected to certain types of surveillance, and so on and so on. So it's not that the ECHR doesn't protect these things, but the Charter protects them more specifically. But if we go to the next slide here, you can see a lot of bits in, well, kind of purpley, yellowish, purpley color, I suppose. If we look at equality, equality is, the ECHR is fairly weak on equality. We've got protocol number 12, which is a non-discrimination protocol, but a lot of countries have not ratified that. I think Estonia hasn't, as far as I know. Germany hasn't, Ireland hasn't, so there's 3 countries that I'm familiar with now. The Charter protects against discrimination. The ECHR only protects against discrimination in Article 14, and only in connection with another right. So if you want to invoke non-discrimination under the ECHR, one of the most famous cases in that field is a case concerning discrimination when it comes to access to education. Yeah? So you have to invoke another right, the right to education, and you say, well, I'm exercising this right, I want to go to school, but I'm not allowed to because, or I'm not allowed to go to the school that I want to, or I'm sent to a worse school than I should be going to because I'm Roma, right? They would be the typical cases. Or because I'm part of another marginalized group, okay? So that's where the ECHR kicks in. The Charter doesn't need that. You don't need to say, well, I'm exercising another Charter right. You can just say I'm being discriminated against on the basis of my religion, on the basis of my, say, ethnicity, and so on and so on. And there are additional rights then in this chapter. Importantly, the whole solidarity chapter, which contains what we call social rights, rights to social and economic rights and cultural rights, rights of workers, right? Right to be paid a decent wage, or right to, be given fair and just working conditions. Those rights are not protected in the ECHR. Why are they not protected in the ECHR? Because the Council of Europe, to which the ECHR belongs, the Council of Europe has a separate treaty for economic and social rights, this so-called European Social Charter, which has its own enforcement mechanism, which is the Committee on Social Rights. But the Committee on Social Rights is not a court. It doesn't work like the European Court of Human Rights. The European Court of Human Rights has an individual complaint. So if you are the subject of a human rights violation and you have gone through the courts in your member state, you can then go to Strasbourg as an individual and say, well, I've had my human right to, say, freedom of expression violated by this particular state, and I'd like to get an acknowledgement of that by way of a judgment by the European Court of Human Rights. You can't do that with the Committee of Social Rights. It does not work like that. It doesn't have individual complaints, okay? So it is much weaker in terms of enforcement, and deliberately so. Now, you will see, if you can see it, there are some asterisks on the side of some of these rights, some in brackets, some not in brackets. And that is an important caveat. It's an important limitation of the Charter, because the Charter distinguishes between rights and principles. And those with an asterisk are Charter principles only. They're not rights, even though they might say they are rights. So for instance, Article 27 says workers' right to information and consultation, but it's not a right, it's a principle. And the asterisks in brackets mean these are provisions that are partly rights, partly principles. Now, I don't want to go into great detail, but principles are limited according to the Charter. Why have they been put in? Why has that distinction been put in? Because the member states were a bit nervous about giving you and me as citizens rights to as these economic and social rights. Because if I have a right, say, to collective bargaining, if I have a right to, if I have certain workers' rights, if I have a right to decent housing, social security, that costs the state money. And if there's one thing that politicians don't like very much is not having control over how much money is being spent. So they wanted to put in some protection for themselves, right, for the state's budgets, and they have found that in the way of designating these as principles. Principles have two limitations compared to rights. They have to be implemented first, so the member state in question or the EU has to enact the principle somehow. And secondly, even if that principle has been implemented, the right can only, the principle, the Charter principle, can only be invoked before a court in the interpretation of that particular Charter principle or in decisions on the implementing act's legality. So it is very much limited in terms of justiciability, but also that it needs to be switched on somehow. So that limits the Charter. So I don't want to, sing the praises of the Charter and say everything is great, you should only be using it. You can't, because you're limited, certainly in this field where we have these non-overlaps, this lack of overlap between the Charter and the ECHR, because some of the provisions are not rights, even though they might pretend to be, they're only principles. We've also got no protection, or not much protection, of citizens' rights in the ECHR. The only thing we have is a right to vote in Protocol 1, Article 3, excuse me. But obviously, the EU has citizenship and a concept of EU citizenship. We don't have something like that in the ECHR, so it's perfectly clear why there is no such protection. And then we've got the justice chapter with the right to an effective remedy, with the nebis in idem principle, and other important protections, certainly in the field of criminal law, but also when it comes to access to courts and a fair trial, right? Okay, now let's look at it in a little bit more detail. Now, the Charter, I should say, is also limited in its own scope. The Charter, you can only invoke the Charter in the member states if you're in the scope of EU law, if the member state is implementing EU law. The Charter always applies to the European Union, so every European Union Act has to be Charter compliant, so the European Union might put in place, enact a directive, and that can then be challenged before either a national court and eventually before the Court of Justice for compliance with the Charter if you don't like it. That has happened, right, in various cases, for instance, with regard to data protection. But if you want to invoke the Charter against your member state, it only applies where the member state is implementing EU law. So if you, I don't wish that on you, but if you step out after this lecture and you're arrested by the police, it's not quite clear that the Charter applies to you, because it really depends on why the police arrest you. If they arrest you because there's a European arrest warrant for you, then the Charter applies, because that's EU law, they're applying EU law. If they arrest you because they think you have just robbed a bank around the corner, then EU law most probably does not apply to you, and you cannot invoke the Charter. You have to rely on the Estonian constitution, the ECHR, and your good luck as well. Okay, so that's the difference. The ECHR, of course, applies in every situation. It's always binding on the member state courts. The internal effects of the ECHR differ from state to state. It really depends. If you go through the 46 constitutions of the 46 Council of Europe states, the ECHR will have a different status in each constitution. I think the most generous one is probably Austria, which basically uses the ECHR as almost, it has constitutional status there. And other countries like Germany or Ireland, it has a lesser status. It's below the constitution. So its importance in the national legal order differs from state to state, and its effects differ from state to state. The EU Charter is obviously the same, has the same effects everywhere. It comes with the effects of EU law. EU law is a great thing if you can invoke it, because EU law has primacy over domestic law, including the domestic constitution. We'll talk about that in a second. And the Charter has, as far as rights are concerned, direct effect. So you can actually invoke the Charter in an Estonian court without having to explain that, very much apart from the fact that Estonia is a member state of the EU, which I think most judges will by now have understood. Okay? You can also refer cases, the National Court can refer cases on the Charter to the Court of Justice. And every national court can do so. When it comes to the ECHR, referrals to the European Court of Human Rights are very rare. It's only a handful of states that have ratified Protocol number 16. I saw that Estonia has done so, but only then, it's only the highest court. And that reference, when it comes back, is not binding on the highest court. It's obviously highly authoritative, but not binding, whereas references by the Court of Justice, from the Court of Justice that come back to the national court, are binding. They have to be complied with. So that's the theory. Now, let's have a look at the case study, the right to an effective remedy. It's something I've been thinking about for a good while now. I still can't claim I fully understand everything about it, because it's very complex, but I'll give you an example of how the Charter adds value to what is happening to the concert of fundamental rights in the member states, and gives individual claimants something that they might not be able to get either from domestic law or from the ECHR. So that's my general argument. Okay, so we've got the right to an effective remedy. I'm only focusing on Article 47.1. Everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal in compliance with the conditions laid down in this article. Let's ignore the rest for now, but if you are familiar with Article 6 of the ECHR, it's very, very similar. It's broader in the sense, in terms of scope. Article 6 of the ECHR contains a limitation. It only applies in civil in cases concerning a person's civil rights and obligations or criminal charges against them. So it does not apply in a purely administrative law context. Article 47 has been broadened out to everything. So it applies across the board. And It also gives, and if you look a little bit further to the second paragraph, a right to a fair and public hearing within a reasonable time by an independent and impartial tribunal. So that'll become important later on. So you also have a right to an independent and impartial tribunal, very importantly, okay? So if you have an EU law right, a right and freedom guaranteed by the law of the Union, you then have a right to an effective remedy. An effective remedy before either the Court of Justice, but it's rare that as an individual you will ever end up directly before the Court of Justice. Most of the time, EU law is applied and enforced by the member states through their administrations. And that means that if you want to challenge what they're doing, you have to go to the national courts. So it gives you a remedy before a national court. And that's where things get interesting, okay? So the case study I want to give you is this. It's I don't have to read everything. I'll read it for you, okay? It's a case of KL and X. It's a case that is based in Poland or came from Poland, from a Polish court. So KL was an employee on a fixed-term contract, and she was dismissed from her job by her employer before the fixed term was over, okay? And the employer did not tell her why, okay? Just said, you're dismissed. Thank you very much, off you go. Under Polish law, that was perfectly legal. If you look at the Polish legislation, as a second bullet point, it says, the statement by the employer concerning the termination of an employment contract of indefinite duration, so that is a contract that has not got a fixed term, yeah, it runs forever, basically. So if we have a contract of indefinite duration, with or without a notice period, shall state the reasons justifying that termination. So if I give notice, if I'm an employer and I give notice to my employee who has a contract of indefinite duration, I have to give them the reason. I must say, well, because you're always late, or because you're not working satisfactorily, or you've stolen money, or whatever. Like, one of the reasons that might get you out of the contract. If the person was on a fixed-term contract, I don't have to say anything. Now that is a problem under EU law because we have a directive, you might be surprised to hear, that says that in respect of employment conditions, fixed-term workers shall not be treated in a less favorable manner than comparable permanent workers, solely because they have a fixed-term contract. Now you can see a problem, yeah? The Polish legislation is not in compliance with the directive. Okay, so we know that. But the question is, what can I do about it? Yeah? Okay, I know that my member state has violated the law. Okay, what can I do about it? What can I do about it? Well, I've got a problem here because I've got a case between two private parties. And in EU law, I cannot invoke a directive directly in a horizontal case when I've got two private parties fighting over something. I can invoke a directive directly in certain circumstances if it's clear, precise, and unconditional against the state, but not against another private party, okay? So I can't rely on the directive in this case. The question is, can I rely on the charter instead? Short answer is yes, I can, because otherwise I wouldn't be using this case to show you that the charter has added value, but why? Okay? So what we have to look at is, first of all, are we in the scope of the charter? Which right are we going to invoke? Does it matter that we're in a horizontal dispute between two private parties? And if none of this matters, and I've ticked every box, is what remedy do I get? Does my employee, Miss KL, now get the reasons for her dismissal or not? Will she learn why she has been dismissed? Okay. Now, let's look at the scope of the Charter. I've already told you the Charter only applies where a member state is implementing EU law. Is our country, Poland, here implementing EU law? Well, you could say, well, they're not because they've done it wrongly, right? I mean, they haven't implemented EU law, but they should have, right? I mean, that's the clue. So they acted in the scope of EU law in this case. And they have, because they have adopted legislation, they've adopted legislation specifying and giving specific expression to the employment conditions governed by the directive. They've adopted legislation that says something about dismissal, and they've said that only applies to people on an indefinite contract. So they're acting in the scope of this particular directive, which bans discrimination between fixed-term workers and workers on indefinite contracts. So the Charter applies to this case. That's good, yeah? If we tick the first box, it's the first hurdle, and it's not always easy to show that the Charter applies. In our case, it's relatively straightforward, but it's not always easy. That also means that that Article 47 of the Charter applies, and it's an important lesson from the case law, perhaps. It might seem very obvious, but whenever a member state is applying EU law, whenever a member state is acting in the scope of EU law, there's also a right to an effective remedy under EU law. Now that seems, to those of you who are not familiar with how, or not that familiar with how courts work and how national legal orders work compared to what the EU, or how they interact with EU law, that might seem fairly innocuous. Yeah, you mightn't feel touched by it, but for EU lawyers, that is a big deal, because obviously the right to have a certain remedy that might not exist under domestic law otherwise is a big deal, because EU law operates generally on the basis that national law provides the remedies and that no new remedies need to be created in order to give effect to EU law. And Article 47 challenges this, very much so. And that's where we are at the moment in the case law, in the development of the case law by the Court of Justice. The Court of Justice over the last couple of years has really been pushing out Article 47 and really been pushing out this right to an effective remedy, which leads to further and further encroachments of EU law on what is typically called national procedural autonomy, where the national legislation actually determines how things are done and how EU law is enforced. And that is no longer quite the case. So it's an important development. Anyway, don't want to dwell on this for too long. Let's go back to our case. So what charter right are we talking about? Now, obviously, I've been talking about Article 47 for ages, so that's it. Article 47.1 is the right to effective remedy. It has horizontal effect, which is important because we're in this private law relationship, and that has been clear since the Egenberger case. I'll talk a little bit about Egenberger in a second. But what the Court of Justice has done in Egenberger, it's given us a sentence, which is Article 47 is sufficient in itself and does not need to be made more specific by provisions of EU or national law to confer on individuals a right which they may rely on as such. That means Article 47 has direct effect. And this sentence, if you trace it back, I don't know how familiar you are with the search engine on the CJEU's website, but if you put that sentence into the search engine, it'll come up again and again and again. And if you are familiar with how the Court of Justice operates, or has been operating for the last 15 or 20 years, it often uses the same phrases again and again and again. So you will have a lot of déjà vus when you're reading case law, because the judges will typically use the same paragraphs here and there, and then there might be a modification in the 7th paragraph somewhere, and that's the development. And you will find this phrase reappear and reappear and reappear. So it's really important. The Court of Justice says, well, Article 47 has horizontal effect. Then the next question is, can it stand on its own 2 feet, metaphorically, or does it need to be invoked alongside another fundamental right? Up until the case of KLVX, it was always the case that the Court of Justice said, yeah, there's a violation of Article 21 of the Charter in conjunction with Article 47. So there's always 2 charter rights that were being invoked next to each other. Now, we didn't have that situation. Why? Because the Charter does not contain a right not to be discriminated against because you are employed on a fixed-term contract. There's nothing on fixed-term contracts in the Charter. I mean, the Charter contains a lot of rights, but nothing as specific as that, okay? So, and that is the big difference to the previous case law. So if you look at Egenberger, I told you I was going to say a little bit more about that. That was a case of discrimination on the basis of religion. Somebody applied for a job with a church in Germany. They were not given that job because they were not a member of that church, right? They were a member of no church. They were agnostic, atheistic, or whatever. Instead, the job went to somebody who was a member of the church, right? Now, normally you can't do that, right? I mean, if you apply for a job here at the university and they tell you, well, you know, you're, I don't know, Catholic and we're not going to give you the job because of that, that's not going to work. That would be illegal. But obviously churches have a right to discriminate for certain jobs on the basis of religion because, you know, if I wanted to be a Catholic priest, I should probably be Catholic, right? I mean, that would make sense, right? So there is a justification for this. But in this case, there wasn't, because her job had nothing to do with the mission of the church or anything like that. Now, the good thing is that the Charter also protects against discrimination on the basis of religion, okay? So we have a right that said exactly the same thing as the directive in the Egenberger case. So it was easy. They were able to say Article 21 of the Charter in conjunction with Article 47 has been violated. We don't have that here. We don't have a right in the Charter that mirrors what is in the directive. So they had to use Article 47 on its own. And that broke what had long been discussed as being an intrinsic link in those cases between the directive that couldn't be applied because it doesn't have horizontal effect and the Charter right that you then invoke instead. That's no longer there. So importantly, Article 47 applies on its own. So we've, you know, and this is how Court of Justice case law, and case law probably everywhere, it develops incrementally. Courts rarely go from zero to hero, right? They don't go from, oh, we're not protecting this at all, to overnight saying, now we're protecting everything. They will do so incrementally. There's a case, they're going to give a little bit, and then they're going to give a little bit more, and they're going to move a little bit more, and a little bit more, and that's where we are with Article 47, I think, anyway, in this case. So we can see it's thrown off some of the shackles, some of those restrictions that have been there over time, and we now have Article 47 applying in and of itself. Okay, so was Article 47 violated in this case? It's not so easy because, you know, Article 47 says nothing about discrimination between part-time workers, not part-time workers, excuse me, between workers on a fixed-term contract and workers on an indefinite contract. It says nothing about that. But the reason that there was an issue here was not the discrimination, but it was the fact that the employee, in our case, was never told why she was being dismissed. And if you don't know why you've been dismissed from your job, it is very difficult for you to challenge your dismissal, right? If your employer says to you, I'm going to dismiss you because you're always late for work, and you say, but that's not true, and then at least you can contest your dismissal. You have something you can go to a judge with, to a labor court, and say, well, actually, this is not true. I never stole the money, with somebody else, right? Or I'm not the one who's always late. It's my twin brother, John, right? Something like that. But if you don't know the reason for your dismissal, you can't challenge it. And that's where Article 47 comes in. If I have a right to an effective remedy, well, a remedy can really only be effective if I know what I'm supposed to complain about. Otherwise, you're in this Kafkaesque situation. You know, you've been accused, but you don't know of what. And it's like not a good situation to be in. You can kind of see the logic, okay? So that's why Article 47 kicked in. But if we go through the test of Article 47, we can see, okay, I need to be able to invoke a right protected under EU law. In our case, that was the right in the directive, not to be discriminated against because I'm on a fixed-term contract. Does it matter that that right itself does not have direct effect? No, it doesn't. And that is another thing the court had clarified in one of these other cases where it was, broadening the scope of Article 47 step by step. In Deutsche Umwelthilfe, there are loads of Deutsche Umwelthilfe cases, so it's one of them, one of the many, okay? And for that reason, the court was able to find a violation of Article 47. Now what we have here is the maybe unusual situation, or maybe the unusual conclusion that we have a violation of Article 47 in a horizontal dispute where a member state had wrongly implemented a directive. Now that's, depending on how much of an EU law connoisseur you are, that is quite interesting, because as we can kind of in this case, we're able to circumvent the lack of horizontal direct effect of a directive by going to the Charter and applying that instead, right? Now the question then is, what is the remedy? What do I get? And that's where the case is again quite interesting, but again the Court of Justice has used or has employed a solution that gives maximum effect to Article 47, which shows the added potential of the Charter, right? Now we have the doctrine of primacy of EU law. The doctrine of primacy of EU law asks national courts to do two things. The first is they must interpret national law as far as possible in accordance with EU law. If that is not possible, they must then not apply national law and apply EU law instead, if there's something to apply. So we've got the duty of interpretation and conformity, if not possible, disapplication. Now here, we have a very clear wording in the national legislation that says only workers on an indefinite contract have to be told of the reasons for their dismissal. I can't interpret that in a way that says every worker has to be given a right to be told of the reasons for their dismissal. That doesn't work, right? The wording is too clear. So it's disapplication. Okay, great, we'll disapply, but how? Okay, something we don't often think about. I hadn't thought about it that much before I came across this case, I must admit. Because, that's where usually the story ends. Oh, just disapply and everything. But what do we disapply in this case? Now, this is our law, right? So we've got the national provision that says the statement by the employer concerning the termination of an employment contract of indefinite duration with or without a notice period shall state the reasons justifying that termination. Okay, option one, I disapply everything. Just get rid of the provision, yeah? But if I'm the claimant in this case, that doesn't help me very much, because now I have no right whatsoever. Nobody has a right to be told of the reasons for their dismissal. Now, that removes the discrimination issue, right? If you don't give anyone a right, you're not discriminated against anybody. But it doesn't help me from the point of view of an effective remedy. I still haven't got an effective remedy. I still haven't got a remedy. I can't, I'm still in the same position as I was before. Instead, the Court of Justice has created a legal vacuum. Now, nobody has a right to be informed. That is probably incompatible with EU law, with the right to an effective remedy. So the legislature may have to go back to the drawing board and draw something new up, to amend the legislation. That can take years, and they might never do it. You don't know. Okay. The Court of Justice probably wasn't too happy about this. So they suggested we just disapply insofar as the provision is incompatible with EU law. That's a good idea. Partial disapplication. That is something we don't really find much about in the literature, or maybe even in the case law. And what they've suggested that the National Court do is this, that they just strike out three words. Well, they didn't say that. They just said insofar as, but that's how I interpret what the Court of Justice has said. And if you just strike out these three words, you come to the conclusion that the statement by the employer concerning the termination of an employment contract, with or without a notice period, shall state the reason justifying that termination. If that is how I disapply, then I can, if I'm the National Court, I can order a remedy for my applicant, for KL. I can tell her, well, I'm reading the provision to be this, and therefore your employer has to tell you why they have fired you from your job, okay? Now that is great, but that again shows how far the Charter, Article 47, or maybe EU law in general, can encroach on domestic lawmaking, where the domestic legislator, for whatever reason I wasn't able to figure out, the Polish legislature, at some point when they adopted that legislation, thought it was a good idea to only give people on an indefinite contract a right to be informed of the reasons, and give other people who are on a fixed-term contract no right to be informed of the reasons for their dismissal. And now the national legislature cannot go back and easily say, well, we're not going to give anybody a right to be informed, or we're going to give everybody a right to be informed, under certain circumstances, and so on and so on. So that decision has been more or less taken away from them. Now, obviously, they could still revoke that provision and reenact a new one, but they probably won't do that. So there is a tension here between the competence of the EU and the competence of the national legislature. I'm not saying that this is wrong, right? I'm just pointing that out. And that shows the power of the Charter. And that shows the power of the Charter compared with the ECHR, because obviously the ECHR, in most countries, that result would not have been achieved on the basis of Article 6 of the ECHR, because in most countries, at least, Article 6, you wouldn't be able to rely on the ECHR against national domestic legislation in that way. Yeah, you wouldn't get that remedy. Yeah. Okay. So that's where the Charter is particularly strong. That's, in my view, the added value of the Charter. Yeah? It's a powerful provision. Article 47 in particular is a powerful provision available to the national judge. I would also say it's a provision that contains positive obligations to create a new remedy if it doesn't exist already. It's increasingly being relied on by the Court of Justice, so it's one to watch, definitely. And despite its limited scope of application, the Charter only applying in the member states when the member states are implementing EU law, because of its added, the additional rights that there are that you mightn't otherwise have, the particularly strong enforcement provisions, the Charter has value, it has added value, and I think it's a really important aspect that I wanted to highlight here today as one of the things I wanted to talk about. Okay, now, first part is over, you'll be relieved, but let's take one step back. So I've talked about the added value of the Charter, something where we don't have, something maybe the aspect of the Charter that the ECHR does not cover, where the ECHR does not have much to offer in terms of remedies. But what about areas of overlaps? Now we have, as I said before, we have a lot of overlaps between the Charter and the ECHR. But that also means that we have the Court of Justice interpreting the rights, identical rights, and we've got the Court of Human Rights interpreting identical rights. So how does that work? Now, we have that quite a lot, in particular in what you might call the area of freedom, security, and justice. So in EU criminal law, in EU migration and asylum law, we have a lot of overlap and a lot of activity by both courts, right? So for instance, they will both have dealt with living conditions in reception facilities for asylum seekers, right? They will have both dealt with prison conditions where European arrest warrant has been issued and somebody is locked up in prison in a member state and the conditions are just not very good. Can they do something about it? We'll have, both courts have extensively talked about data protection. And both courts have talked about the rule of law. And I want to use the rule of law as an example as to how these courts interact with one another. I'll come back to that in a second. Now, the ECHR is not part of EU law. Yeah? The EU is not a party to the ECHR yet, okay? They will maybe be one day, I don't know, we'll live to see it, but it might happen. And I'll talk about that at the very end, briefly, I promise. But nonetheless, the ECHR has been, as I said before, the main source of inspiration for the EU's own fundamental rights. Both the Charter has been is basically a copy and paste job in some parts, but also the general principles of EU law that the Court of Justice had developed before. And we've got a coordinating provision in Article 52, paragraph 3 of the Charter, which says that insofar as this Charter contains rights which correspond to rights guaranteed by the Convention for the Protection of Human Rights and Fundamental Freedoms, that's the ECHR, right? The meaning and scope of those rights shall be the same as those laid down by the said Convention. This provision shall not prevent the Union, or shall not prevent Union law providing more extensive protection. So, basically means that where we have these overlapping rights, right? Freedom of expression, right not to be tortured, the Convention standard is the minimum that the EU has to guarantee. That's the absolute minimum. So the Court of Justice has to look at what the Court of Human Rights is doing. in order to figure out what that minimum standard is. Now, the EU law can go further, and the EU will probably claim, the Court of Justice might claim, that they're going further in data protection, maybe, and that they're going further in maybe other areas. But I'm more interested in the ones where they fall behind, okay? But let's look at the rule of law cases first. Now, that graphic looks a bit mad, and I apologize for it. You don't ignore what's written on it. It's not that important. What I want to show here is that the arrows, there's interaction, right? Arrows meaning interaction of some sort, okay? And I'll explain this, hopefully, to you in a way that you will not be too confused. Anyway, okay. So what I want to look at here is Poland and the reforms of the Polish Supreme Court, which happened in 2017. And these were, I think it is probably fair to say, of a kind that undermined the rule of law in Poland. So what had happened is that the legislation reforming the Supreme Court of Poland introduced two new chambers to the Supreme Court. One was a disciplinary chamber, dealing with disciplinary actions against judges and similar stuff. And the other was a chamber of extraordinary review and public affairs. Okay. So these two new chambers were introduced. And obviously, the posts, the jobs in the Supreme Court have to be filled somehow. And that's always a tricky one, right? I mean, the judiciary is meant to be independent of the government and of the parliament. But somebody has to appoint the judges. And somebody has to go ahead and say, well, we're going to take you, but not you. And you're going to be on the Constitutional Court or on the Supreme Court, and you're not going to be on it. But who makes that decision? It's often, in many cases, it's the government or it's the parliament. But how do we ensure independence, right? That's the tricky one. Now, Poland had a system in place where it had a National Council of the Judiciary, and the members of that National Council of the Judiciary determined who was going to sit on these highest courts. And those members of the National Council of the Judiciary used to be elected by all the judges in the country. So it was a fairly independent body for that reason, right? The Supreme Court reformed this. The Supreme Court reforms said, well, all the members of the National Council for the Judiciary now lose their role on this. They're gone. And we have a new procedure in place whereby the members of the National Council of the Judiciary are elected by the Polish Parliament. Obviously, the Polish Parliament, having a majority of deputies who supported the government that wanted to erode the rule of law, right? I mean, that's the background to it. Now, in order to be nominated, to be elected by the parliament, you either needed the support of 15 fellow judges or of 2,000 citizens, right? So, okay, great. And therefore, as a result, there was an election, and the National Council of the Judiciary, it will be no surprise to you, ended up being friendly to the government. There's all government appointees, essentially. Obviously, there was a process, right? That's the great thing about if you want to deteriorate the rule of law, you just put in loads of processes that look kind of kosher, but they're not, right? And in this case, we'll see why. So this National Council of the Judiciary then appointed the judges to these two chambers, the disciplinary chamber and the chamber of extraordinary review and public affairs, which is a great name, because it doesn't tell you anything about what it does. Now, how is that an issue under the Charter or under the ECHR? Well, we've looked at Article 47 before. You see, I kind of like Article 47, okay? It's the right to an effective remedy before a tribunal. And in Article 47, paragraph 2, it says that you have a right to an independent and an impartial tribunal. Independent means that the tribunal is independent of the government and other external actors. Impartial means that the tribunal, the court before which you are, is impartial to the parties before it. So, if you have a dispute with your landlord over rent paid or not paid, obviously the court, if the judge is the landlord's husband or wife, then obviously you that person is not impartial. They have to recuse themselves, some other judge has to sit over it. So that's the difference between impartiality and independence under the law. Anyway, not that important for us. Article 6 of the ECHR is very similar to Article 47, and it says that there needs to be a tribunal established by law. So these are they're the hooks for the cases, okay? Now, the CJEU considers independence and impartiality to be the essence of the right to an effective remedy. You cannot have a right to an effective remedy if the court before which you seek that remedy is either not independent or not impartial or both. Now let's look at the cases. So AK and others is the one here. So if you the color coding, there's reason, there's a rationality behind the madness. The color coding is the yellow cases are Court of Justice cases, and the blue cases are ECHR cases. So we start with AK and others. It's on the left there. It's a 2019 decision where the CJEU was asked to determine whether the disciplinary chamber, which had been filled with these government-friendly judges, is an independent and impartial tribunal. And this followed a preliminary reference from another chamber of the Supreme Court of Poland, which had not been corrupted yet. Okay, so that's what happened in the Polish cases. I think we have dozens of cases now in the Court of Justice, dozens of cases in the European Court of Human Rights, just dealing with Poland. And I'm only looking at a small fraction of it. There's equally a lot of case law on Hungary and other countries in the EU, unfortunately. The CJEU then set out certain criteria for assessing whether a court is independent. And it said, well, those reforms in and of themselves may well be, in theory, compatible with EU law, but it all depends on the precise circumstances of the case, right? So it takes this holistic approach and the objective circumstances in which that body was formed. And in coming to that, to formulating those criteria, the Court of Justice relied on these 4 cases that I've mentioned here. They are lesser known cases. You don't need to worry about them. On the left, there's the 4 little circles. And why does the Court of Justice do that? Well, it doesn't obviously tell us exactly why they do that, but my theory is that obviously they're dealing with a highly political case here, right? I mean, it is quite an accusation if the Court of Justice comes to the conclusion that these judges are not independent and impartial. It's quite a thing to say, well, one of our member states has instituted reforms that lead to a judiciary that is not independent. Right? It's quite a strong statement to be making as a court. So they were looking for backup, right? Yeah. And they found their backup in the European Court of Human Rights case law, and they distilled the criteria from that case law. And applying those criteria, the Court of Justice concluded that the National Council of the Judiciary was tainted, it was not independent. Looking at the overall circumstances, they said, well, look, they terminated the terms of office of existing members of the National Council of the Judiciary. The reform itself, the reason for the reform that the Polish government had put forward was that there had been a constitutional court judgment that said that they should reform the National Council of the Judiciary. The problem was that the constitutional court judges themselves had not been appointed in accordance with the Constitution. So that was a bit of a problem, right? It was dodgy itself. The court also pointed out that this was a root and branch reform which consisted in a considerable modification of the election criteria. Furthermore, it was unclear, because the government never divulged the numbers, whether the people who were elected by the national parliament had ever been nominated in accordance with the law. So, as you remember, they needed 15 judges to support them or 2,000 citizens. Well, there's no evidence that that had actually been the case. So taken together, the National Council of the Judiciary was considered to be so flawed that it also affected all the appointments it had made. Because the body that made the appointments was flawed, incompatible with the rule of law. Every appointment they made to the disciplinary chamber or the chamber of extraordinary review and public affairs was also flawed. And therefore, the judges on these particular chambers were not considered to be independent. This case then went back to the Polish Supreme Court. Obviously, the way it works with the preliminary references, the Court of Justice never applies the law to the facts, but just says, what the law is, and it is then for the national court to apply the law to the facts. Polish Supreme Court received the case back and concluded that while each of these circumstances may not have been enough to call into question the independence and impartiality of the disciplinary chamber, taken together in a holistic manner, they do. Okay, great. Now, a few years later comes the case in the middle. Now, I can't pronounce Polish very well. I'm just going to try it. Dolinska, Ficek, and Ozimek versus Poland, okay? They were two judges who had applied for promotion to the Supreme Court, and they were not successful. They appealed, and that appeal was then heard by the Chamber of Extraordinary Review and Public Affairs, the other one, right? But had been appointed, the judges on that had been appointed in the same way. Now, our two judges, they lost, and they lost, and they lost, and then the last resort they had was to go to Strasbourg, to the European Court of Human Rights. They filed an individual complaint. And so they complained, and they said, our right to Article 6 has been violated. And the European Court of Human Rights, referenced a large amount of case law by the CJU, and I'm picking out only the two important ones. One was the case of AK and others, to show that the National Council for the Judiciary was a flawed body. So the Court of Human Rights now refers to the Court of Justice, which had previously referred to the European Court of Human Rights, to figure out what the law is. And the ECHR then followed this and developed its own test, saying that there must be a manifest breach of domestic law. These breaches of domestic law must pertain to a fundamental rule for appointing judges, and the allegations have not been reviewed properly internally, so there was no proper challenge could be brought. And this case of Dolinska Ficek has become, well, one of those fixed stars, that courts keep referring back to when it comes to dealing with these Polish rule of law cases. So in the Court of Justice, we're now here at LG, we're back on yellow, the one on the right. The Court of Justice had, curiously enough, received a preliminary reference request from the Chamber of Extraordinary Review and Public Affairs. So they themselves said, well, you may have said that we're not a court, but we're going to send you a preliminary reference request anyway. Now, if you look at Article 267 of the TFEU, it says, yeah, national courts, our tribunals, can request preliminary references from the Court of Justice. But the precondition is that you are a court or a tribunal. And that was the question here. Does the Court of Justice just say, look, guys, you may call yourself a court, but you're not? And that's what they did. But how did they come to that conclusion? Well, they then referenced the European Court of Human Rights and, of course, their own case law. But in particular, this Dolinska Ficek ruling. And this is, and they referenced it to such an extent that it is very unusual. The Court of Justice, yes, it does reference the European Court of Human Rights regularly, but it's usually just a line. Yeah? They might say, and by the way, the Court of Justice, the European Court of Human Rights has said X. Or they might say, oh yeah, Article 4 of the Charter of Fundamental Rights, the right not to be tortured or subjected to inhuman or degrading treatment, has to be understood in this way, in brackets, see European Court of Human Rights, blah, blah, blah. So it's usually very short references. But in this case, in LG, it's paragraph after paragraph after paragraph. So we see really how they're leaning on the European Court of Human Rights. And of course, leaning on a case in the European Court of Human Rights that itself leaned on a Court of Justice decision, which itself leaned on the European Court of Human Rights. So you can see how together they have erected the foundations of this rule of law case law, and they keep referring to one another in order to do so. Same goes for the Lech Wałęsa case. He used to be president of Poland and leader of Solidarność movement in Poland. And he had, in 2011, long time ago, he had won a defamation case. Somebody had claimed that he had been a collaborator of the Communist Party, and he won. He said, no, you can't say that. It's not true. And that case was closed. But one of the nice things about the Chamber of Extraordinary Review is but it can review cases that have long time been closed, right? It can just pick them up again. And that was picked up. And he subsequently, 10 years later, lost, right, his case. And then he complained to the European Court of Human Rights, which itself then referenced the Dolinska-Fice case, but especially those those paragraphs in that case that extensively refer to the CJEU. This is why the arrow is in two colors, right? And it also referenced the WZ case, and so on and so on. So you can see, even in this relatively niche market of rule of law and looking at the independence and impartiality of just one part of the Polish judiciary, we have this collaboration, this bouncing off each other by these two European courts. So there is what scholars call a dialogue going on between these courts, and it's extensive reinforcement. What's perhaps more interesting is what happens if the courts contradict each other. Or at least, what happens if we have a situation where the allegation is not that a member state has violated human rights, but that the EU itself has violated human rights, right? Which it might do as well. And that is obviously where things get a bit more difficult. We have this, now we're in the area of asylum law. We have, under asylum law, the so-called Dublin regulation. And the Dublin regulation tells us where an asylum seeker has to apply for asylum. And the general rule is that they have to apply for asylum where they first entered the EU. Now, most asylum seekers don't enter the EU through Ireland or Sweden, but somewhere in the south, right? Greece, Italy. So most of the cases will deal with those countries indirectly. In MSS, that's the starting point, the asylum seeker entered Greece, was fingerprinted there, registered there, and then moved on to Belgium. And they applied for asylum there. The Belgians said, well, now you have to go back to Greece. And he said, no, I don't want to, because the reception conditions in Greece are so dire, and they were at the time, that this is a violation of my right not to be subjected to inhuman or degrading treatment. So in reception conditions, if you read the case and it's like, ooh, this is really bad, you will see that people were kept without food or any support. They had to live on the streets. They were subject to marauding groups of youths who would beat them up, all sorts of things that are really, really horrifying. And the Court of Human Rights said, well, under those circumstances, if Belgium sends him back to Greece and he's facing that kind of a situation again, that would result in Belgium violating Article 3 of the ECHR, the right of any person not to be expelled to a country where they will be facing inhuman or degrading treatment or punishment. Okay. Now, for the EU, that was a problem because under EU law, we operate under the fiction of mutual trust. We believe, or EU law says we believe, that all member states protect fundamental rights to a certain standard, right? And that therefore we have to trust each other, and that therefore a claim that the reception conditions in member state X are not as good as in member state B, or that they are in violation of the charter of the ECHR, that claim cannot hold. That is not a claim. It's a fiction because it's not true in some cases. Right? Now, in the NS case, then the Court of Justice took that up. Now, the color coding at this time is the other way around. I apologize. Court of Justice is blue, or EU is blue, and ECHR is yellow. The Court of Justice then took that up and said, okay, similar scenario, only that the asylum seeker had ended up in the United Kingdom, not in Belgium, but again with Greece. And they said, okay, you cannot send him back, okay, because of Article 3 ECHR, Article 4 of the Charter. But the Court of Justice introduced an important caveat and said that only happens where there are systemic deficiencies in the protection in the member state at issue. Systemic deficiencies, not just because the individual might, in this particular case, be subjected to inhuman or degrading treatment, but because the whole system in Greece had broken down. That was then codified in the Dublin regulation, so that was amended in 2013, I think, And we now have a provision in there, Article 3, Paragraph 2, that says if there are systemic deficiencies, we don't have to comply with mutual trust, mutual recognition. The European Court of Human Rights then corrected the record somewhat in the Tarakel case, which is brought against Switzerland. Now, Switzerland is not in the EU, but Switzerland applies EU asylum law because they're in the Schengen area. And in the Tarakel case, we had a family of asylum seekers, a family with 5 young children, and they were meant to be sent from Switzerland to Italy. Italy's asylum system had not broken down. There were no systemic deficiencies. But the refugee camp that they were meant to be sent to was not suitable for a family with young children. And because of that, the Court of Human Rights said, well, you cannot send them there. It would be a violation of Article 3 ECHR, inhuman or degrading treatment or punishment. Obviously, if Italy promised that they would send them somewhere else, which was nicer, just saying, that would be fine. So the whole idea of systemic deficiencies being the important criterion under ECHR law is not true. The ECHR will always look at the individual, right? Because the Human Rights Treaty, it's about individual rights, not about systemic problems. It seemed that in CK, the Court of Justice accepted this. CK was about an asylum seeker who was severely ill. She had severe mental health problems. And if she had been sent back from Slovenia, where she was, to Croatia, just around the corner, where there were no systemic issues, that would have been a risk to her life, okay? And in those circumstances, the Court of Justice said, well, Slovenia must not send her back to Croatia. So we thought, or I thought at the time, well, maybe the Court of Justice has now accepted that an individual assessment is what is needed. But far from it, because it seems as though the Court of Justice, or this tension between the Court of Justice wanting to look at only systemic problems and the Court of Human Rights saying, no, systemic problems are, of course, maybe relevant, but what really counts is the individual's situation. What will happen to the individual? Will they be subjected to inhuman or degrading treatment or punishment? Which makes a lot of sense. I mean, as I said, from a human rights perspective, and certainly from an individual perspective, I mean, you probably wouldn't care very much whether you're being subjected to inhuman or degrading treatment as a systemic problem or just because they have picked on you, right? I mean, this doesn't make any difference to the individual. The individual has a right not to be sent to another country. And it seems as though that tension is still there, so we can see cases, again, from asylum law, HT in Germany and Greece, as opposed to the Staatssecretaris case, where the Court of Justice continued to insist that no, only when there are systemic deficiencies does this case law kick in. Same with the European arrest warrant, where the Court of Justice seems to be requiring some sort of a breakdown of the systemic or generalized deficiencies system to some degree for a refusal by a member state to execute a European arrest warrant on constitutional grounds. Okay, so we're not quite there. I mean, it's not all brilliant, yeah? The story is not all a happy one. And maybe that's unavoidable because, there are two courts that operate in different systems. The European Court of Human Rights has one aim only, that is the protection of fundamental rights. The Court of Justice is not a human rights court. It is a court that also protects human rights, but it's more like a Supreme Court. It deals with everything, the whole EU system. So it has to have more things, has to keep more balls up in the air, right? But what happens if there is a divergence and it persists? Well, we have case law, and I want to be very quick on this, that says that EU member states, the EU is not a party to the ECHR, that EU member states can be held responsible for violations of the ECHR originating in EU law. That started with the Matthews case and was modified slightly in the Bosphorus case and in the Connolly case. I don't want to go into any detail here, but we can do that in the discussion if you want. And then what might be the next big step, and that is EU accession to the ECHR. This is a timeline. Now, you can't read this because you're too far away, but this is a timeline starting in 1979, so that's a long, long time ago. And it hasn't quite finished yet. We're here. So for a long time, there has been this idea that the EU might itself sign up to the ECHR. Now, they've tried a couple of times. In 1994, the European Commission sent a request to the Court of Justice to tell them, do we have the competence to do that? And the Court of Justice said, no, you don't. Then we had the Lisbon Treaty reform, which gave the EU the competence to accede. We had the reform of the ECHR, which gave the ECHR the ability to take on the EU as a non-state member. And then we had a first agreement on accession to the ECHR in 2013, which was sent to the Court of Justice to check whether there was compatibility with the EU treaties. And the Court of Justice said, no, there isn't. And they listed a long list of reasons why not. So that was in 2014, so it was 11 years ago. So the Court of Justice, so the European Commission and the Council of Europe, they didn't do very much for a long time, and then they went back and they tried to renegotiate the whole thing, and they have now renegotiated it. Well, now, it's not news. I mean, it's almost 2 years ago that they came up with a new accession agreement last year in the spring. And that's where we are. It hasn't been sent to the Court of Justice yet. I think it's, as I understand it, that's what is planned as the next step. The Court of Justice will then have to say yes or no. Assuming the Court of Justice says yes, then there's going to be a ratification process. Every Council of Europe state will have to ratify this. The EU has to ratify this, which may take a long time, nobody knows. And then the EU will be a party to the ECHR. And it will be possible for individuals to hold the EU responsible directly in the European Court of Human Rights if the EU violates fundamental rights. Now, that's where we are at the moment. So you can see it's quite a dynamic relationship. It's a complex relationship. There are many aspects to it. And I find it quite interesting, but obviously that's why I became an academic, so I can talk about these things. Anyway, that's for me. If you want to give us a follow, I've got a new, I'm heading up a new Jean Monnet Center of Excellence. We're called REVEL, which is called Realizing European Values and European Law. So it's all about this kind of space that we're talking about. And you can follow us on LinkedIn or on Blue Sky. We don't use Twitter anymore because they're evil. But anyway, I'm happy to talk to you. If you have any questions, or if you have any comments, comments are always more interesting than questions, but questions are also very welcome. And thank you very much for your time.
Thank you. So I'm going to collect your questions, if you have some, or comments, please. The floor is yours.
Yes, thank you very much, Mr. Locke. I am Madis Ernits. I'm visiting professor here for public law and legal theory. And there were many aspects, but I would restrict myself to this comparison of the articles. And I was asking myself, can we actually compare fundamental rights like this? Because on the field of liberty, if we apply the wide interpretation thesis, that actually the whole liberty is protected. So no doubt it is protected. And then one might ask whether it's right that some of the treaties or some of the guarantees guarantee something that the others do not do, or is it rather so that they in the end end up being the same? On the other hand, if we come to the Leistungsrechte. That means
positive obligations,
in English, positive rights. Then indeed we need something more concrete that has to be granted, and there the differences exist. I agree with that, and that's why I found it particularly interesting, this Article 47 of the Charter, because I think this article has many aspects. I think it is on the one hand perhaps institutional or procedural Abwehrrecht. Means, I don't know the English exact words, so I put it in German to describe it as precise as possible. And it also has some positive aspect, and perhaps even equality aspect. So it has many aspects, and that's why this was the most interesting part for me. But as a comment, I had some doubts whether it's really correct to put it on one line, and you let, what was interesting, you let the dignity out. That as if the European Convention of Human Rights would not protect it, but it does, as you told yourself previously. So perhaps.
Thank you very much. That's a very good question. Yeah, I think you're right, obviously, in what you're saying. That when it comes, especially to these freedoms, these the right to be left alone, basically, right? I mean, that's basically what it comes down to: the right to be left alone. That it doesn't really matter whether my academic freedom is protected by a specific provision that says I have academic freedom, or by Article 10 that says I have freedom of expression. I mean, who cares, right? But I think there is obviously something to it in my own defense, right? I should say that we always have to look at the limitations, right? That's where rights are interesting, okay? At those freedom rights. What are the limitations? And I think that's where this comparison is important, because if you look at the Charter, it has this general limitation provision, in Article 52 that says, well, Charter rights can be restricted, if there's an objective interest and, it's proportionate and so on and so on. But that is only half the story, because we also have to look at the ECHR and see, does the ECHR allow such a restriction? If the ECHR does not, if this is an absolute right under the ECHR, we also have to say it's an absolute right under the Charter. But the same can happen under the ECHR. So the ECHR might be more generous when it comes to restricting the right, perhaps, or the material scope of the right might not be as wide. So Article 47 is actually a good example. Article 6 does not apply in purely administrative cases. Yes, the European Court of Human Rights has tried to define civil law and obligations, or civil rights and obligations, very, very broadly. But there are still cases where I can't invoke Article 6, and I can invoke the Charter. So the comparison, yes, I know it is meant to make something graphic, which may not be, entirely give us the complete picture. So I think there's still some value in it. But yes, you are of course right that when it comes to these freedoms, freedom to be left alone, or human dignity is also an example. The European Court of Human Rights does obviously work from the basis of human dignity, and we haven't really got much in the in the Charter of Fundamental Rights, in the case law, where human dignity was invoked. Even though we have one case, the CG case, where there was a right to at least some minimum level of social welfare support that was grounded in human dignity, which I don't know if the ECHR would probably be grounded in Article 3, something like that. But yes, I mean, I do agree with you, but I still think it's interesting to look at it like that, but bearing in mind your thoughts, of course, that at the end of the day, human rights treaties and civil and political rights, they protect our freedom to be left alone by the state, unless the state has a reason to interfere with our freedom. Thank you.
Maybe some of the students have some questions related to your readings, so you have a chance to ask from the professor things that you didn't understood. Yeah.
may be a bit of a stupid question, but there was at the beginning we talked about how the ECHR or the fundamental rights is like adds value to the ECHR. My question is, why not make it as one? Like, why not put them together, and why do they need to be separate if one adds to the other?
Yeah, I mean, that's a very good question, because back in the days, that some people had that idea. Yeah, the ECHR should just be, the EU should just accede to the ECHR, and that will be the end of the story. But that's not how it happened. I mean, the main reason is that the two are just that you know, the European Convention on Human Rights is just a different international treaty. There are 46 states, and the EU we only have 26. And that when the EU started writing its own fundamental rights, they wanted more. And that's why they have the Charter. They could have just said, we're going to copy the ECHR over, or we'll just have some sort of a renvoi, yeah, as the comparative lawyers say. We're just going to say, we'll consider ourselves bound by the ECHR. But they didn't. I mean, they didn't do that. So that's why we have the two.
But they still use one another so often.
They do, but they don't. They do refer to one another, but it's obviously not the same. It's not the same thing, because in some cases you will find some deviation, and then obviously it's difficult for the person on the ground, the national judge, to apply, because they are in a conflict. They have to apply EU law, but they also have to apply the ECHR, and they might say, well, I mean, the ECHR says X, EU law says X plus 1. So what am I going to do? So that's a tricky one. Yeah, it's not ideal, but that's the way it is, I'm afraid. Yeah.
The problem is that time is over and the professor needs to take a plane. But do you have another possibility for another question?
Yes, sure.
So you can pick
a quick one. Yeah. No, please. Yeah.
Thank you very much. Thank you for the interesting lecture. Is it possible to explain very simply what this Polish employee had to do to present this case that Polish national law is not in compliance with the directive? What is the procedure?
Well, I think I don't know exactly, but they went to the Polish labor court. I mean, whatever court has jurisdiction to hear employer-employee disputes, and they had a good lawyer. Yeah, clearly, they probably didn't come up with that themselves, and that lawyer found the directive and said, "Look, I mean, this is incompatible." And the national court, fair. I mean, I have to give them credit. They took that up, because a lot of national courts, but it can happen that a national court will just say, "Well, I'm not going to engage with this." Yeah. Simply, I'm going to apply national law, don't care. But they took it up. They realized that there was a problem with EU law, and they sent the case up to the Court of Justice. Now, I would have to look at the case itself. Sometimes you can see how good the national court is at EU law. The question then is very good and very well presented. Sometimes the national court sends relatively vague questions to the Court of Justice, and the Court of Justice then goes through them and figures out what it actually wants to, what the actual question is. But that's all it needed. So it's very easy access, in theory, to the Charter of Fundamental Rights. You have to have a case that is in the scope of EU law. You go to your local court. I mean, it can be really the local court district of whatever, Tallinn or something. And that judge then has to enforce the Charter.
But what if they don't?
Well, then you have a problem. You then have to appeal under national law in the hope that the higher courts will see the light, right? That they will realize what is at stake. You have to appeal again if that doesn't help. The highest court has to refer cases to the CJEU if there's an EU law point. But if the courts don't believe you that you have a point, there's not much you can do. I mean, that's, at the end of the day, that's where the road ends, right? I mean, and that's why it's so important to have good education in EU law, that the judges know about these things and that they apply EU law correctly.
Thank you.
You're welcome.
Okay, thank you. I think we have to finish now.
Yes, thank you very much.
We have to leave, unfortunately. And thank you all for participating.
Thank you very much. Thank you.